welcome you at the panel, which is organized by the European Data Protection Supervisor's Office. My name is Wojciech Wiewiorowski. I'm the Assistant European Data Protection Supervisor. I'm the Deputy of Giovanni Buttarelli. And since 2014, we both elected by the Council and the Parliament by the Common Accord, try to set the standards for the supervision in the European Union institution bodies and agencies. And we decided to concentrate this year on the very core activity of the European Data Protection Supervisor, which is the supervision, which is having the overlook over what's going on with processing of the data in the EU institutions, bodies, agencies, and on the border between the EU bubble and the member states. And we chose area of freedom, security, and justice as the part of the story, which is at the moment one of the most controversial. As you know, in the program of the conference, the abbreviation AFSJ was used, and I met already several people who said that they had no clue what is its abbreviation all about, and they had to go into the internet to find out that it's not African Federation of or Americans for Social Justice or Artificial Intelligence Facilities. But it shows also how we forget about the things which were very nicely invented some years ago, also as names of the areas which European Union should deal with. Area of freedom, security, and justice. Freedom, security, and justice at the same time. To have the place where there is a freedom, to have the security, because each of us as the European citizen or as a person who is just a visitor in the EU wants to have the security, wants to be secure in the countries, want to travel securely around. But at the same time, justice. Justice not only understood as jurisprudence, but I would recall the times when both with Christian, who is here with us, we were in the student organization which is called European Law Students Association. This organization, ELSA, had in its vision the words, "the just world in which there is a respect for human dignity and cultural diversity." And this is actually what this justice in the name of this area means. At the same time, being the just world, but at the same time respecting the human dignity and respecting the fact that the countries themselves, the states, are differing one from another. So there's probably not a full harmonization that can be achieved at this very moment. And starting from this point, I would like to remind the Article 67 of the Treaty of Functioning of the European Union, which says that the European Union shall constitute the area of freedom, security, and justice with the respect to fundamental rights and different legal systems and traditions in the member states. And one of the practical outcomes of that was the fact that there was a series of institutions and a series of bodies that were created in order to first facilitate this kind of cooperation between the member states, but also to organize it in the European bubble, and at the same time to ensure that the human rights are observed. So we will be talking today about Europol. We will be probably talking about Eurojust. We will be talking probably about European Police College, the EU LISA, which is the agency dealing with large-scale IT systems. We will be talking about European Border and Coast Guard agency, which is Frontex. All these institutions, all these agencies have been created in order to try to organize the cooperation between the countries, but they also have created the kind of hydra that exists in the European Union, which is the large-scale database system. Hydra has some bad connotations, but actually what is very significant is that no matter how you try, it will grow. It will grow up, and it's normal. It's something that we have to be used to, because also interoperability between these databases, interoperability between the systems is the, let's say, logical step in the direction of having the efficient systems. But what is the most important is to have the system which is still observing the human rights, which is still observing our freedoms, and which is not endangering them at the places where the cooperation is rather expected. I am assisted today with a group of excellent specialists. Everybody says that at the beginning of the panels, yeah? But I have this opportunity to say that I'm really assisted by the main specialist in the subject. The moderator of today's discussion will be Teacher McIntyre, who is the chair of the civil rights NGO Digital Rights Ireland. Well, for those who are dealing with data protection, Digital Rights Ireland is one of the cornerstones of the civic society actions in this field. He's also the professor in the University College of Dublin and practicing solicitor specializing in data protection. We have with us Sophie in 't Veld. Sophie in 't Veld is the member of the European Parliament since 2004. Once again, for most of us, there is no need to explain who is Sophie in 't Veld, but since there are people here who don't have this permanent contact with the European institutions, they are here in the room, let me say that Sophie is the member of the ALDE group, which is Alliance of Liberals, Democrats for Europe, and I think it's also important to remember about this three words which are in the name of this group, because this is on one hand pro-European, but on the other hand on liberal values and also about the democracy itself. And Sophie is also the chair of the European Parliament Privacy Platform, which had a session yesterday here during the conference. Then next to me is Clara Guerra, who is the senior consultant in Portuguese Data Protection Authority, but it does not say what it should say, because Clara has more than 20 years of experience of work in the institutional level in data protection, and it includes the chairing of the Schengen Information System Supervisory Coordination Group, and being the member of the VIS, Eurodac, Customs, supervisory groups, and also being the one of the main members and the chair of the European Joint Supervisory Body for Europol, which was the previous supervisor of the Europol activities. And later on, she was also influential in preparing the new scam of EDPs, being the supervisor of the Europol itself, and the data protection authorities in the country supervising what the police does. And we have with us also Christian Wiese Svanberg, the Chief Privacy Officer and the DPO of the Danish police, Denmark having the very special position also in this area. And what is also important, since January 2019, Christian is the DPO of the Danish Passenger Information Unit, so he's also responsible for the oversight of the activities, internal oversight of the activities of PNR directive in the Danish police. But what is also important, Christian was the member of the DPAs group, also chairing this during the Danish presidency, so also having an influence on what is now in the law. And last but not least, a representative of EDPs. We don't have Delphine Harou today with us, but we have Fanny Coudet, who is the legal officer in EDPs office and who is the part of supervision and enforcement team for Europol, so specializing in this area and specializing with in the supervision over this agency. So I hope that will be an interesting discussion. We know that Sophie in 't Veld will have to leave us during the panel because of the other commitments, but we are staying here by 3:30 and we will reserve the time for the discussion. Looking at the faces in the room, I can imagine that that will be a very vital discussion about the subject. TJ, the floor is yours.
Thank you very much. Before I hand over to the speakers who are genuinely the experts in this area, I'd like to say a little bit about what I do know, which is the civil society perspective on this area. Why is it particularly difficult? Well, it's particularly difficult because these are databases which in many cases have information on people who are uniquely vulnerable, refugees, for example, where the misuse of that information, the leaking of the information on them, can be particularly devastating for them. And even inaccuracies, not deliberate misuse, can be very damaging. For example, we had a case in Ireland not too long ago where somebody was wrongly registered on Eurodac as having applied for asylum in Italy, when in fact that wasn't the case. And you can imagine the disruption caused to their lives by that fact. It's challenging for civil society because these are European level systems, and civil society tends to be organised at a national level. So we don't necessarily have the kind of Europe-wide expertise from a civil society perspective to give a useful input. We're probably uniquely dependent on the supervisory authorities, on our friends in the Parliament, to actually exercise proper oversight of what is going on. It's very challenging because it is an area which already, to some extent, lends itself to political abuse in a way that might become more prevalent. You've probably seen that Russia, for example, has weaponized the Interpol red notice system by placing critics, such as Bill Browder, on the system so that they are, in effect, detained wherever they land. And there have been accusations that Poland has done the same in respect of one Ukrainian critic by placing her details on the Schengen system so that there is an alert for her, thus effectively precluding her from entering the Schengen zone. And obviously there are possibly underlying questions there about how far we are going to go with mutual recognition, and particularly some of the questions that have arisen after the European Court of Justice judgment in the Selmer or the LM case. So I think some very challenging issues there. But without further ado, I'll hand over to our first speaker, Sophie.
Okay, thank you very much. So the title for today is about checks and balances. And let me start by saying that I think that the checks and balances that we have on all those systems, databases, surveillance systems, and what have you, those checks and balances are totally inadequate for a number of reasons. And of course, every time that we are pushed in the European Parliament to pass legislation, any kind of, let's say, repressive law enforcement and security legislation, and I'm not challenging the need for such legislation to be passed, but every time we are told, oh, don't worry, all the safeguards are there, all the oversight mechanisms are there, but they're not. And I think it's been tested a few times in practice, not nearly often enough. I would really recommend to every single person on this continent to go to court and challenge those laws. I've done it a couple of times myself. For example, I challenged the French surveillance law in court, and they basically told me to, not bother about it. So now I've asked the same question to the human rights courts in Strasbourg. But the point is that it cannot be down to individual citizens to enforce the laws, to enforce their rights. I mean, somebody like Schrems and the actions that you have taken are fantastic, but it shouldn't be down to citizens and NGOs to make sure that the laws and that our constitutional rights are being respected. This is for the European Commission. But I think these cases also highlight the weakness of the systems. And I have noticed, I've been in Parliament for quite a while, which has disadvantages, but one of the advantages is that you actually have a very good overview of all the legislation that has been passed. It's, and it's salami tactics. Every time there is a new piece of legislation, every time we are told it's urgent and it's essential and indispensable, and the salami tactics over the last 15 to 20 years have basically led to giant salami sausage now sitting in the European Union, and oversight and legal redress possibilities are close to zero. We have seen this also, for example, when we did the inquiry in the European Parliament following the PRISM revelations. You may remember the NSA spying on us. At the time, we were still shocked about that, imagine. And it showed that even the national oversight mechanisms are completely ineffective. Now, they may have improved a little bit in some member states, but clearly not in all member states. And the real problem is, and I've made this point here at this exact same table yesterday, is that all the law enforcement and security measures have increasingly been taken at European and international level, but protection of rights is still very much a local issue. So I think there are a number of things that we should do. First of all, we should start by a massive evaluation of all the measures that have been taken over the last 20 years to see, are they effective? Is oversight effective? Is legal redress effective? Are these measures maybe overlapping and interacting between each other, and therefore, even if each separate piece of legislation itself is not violating fundamental rights, maybe the interaction between them does. The European Parliament has called for such an evaluation in fall 2011. So that is what, 8 years ago, 7 years ago? Nothing has been done. All the European Commission does is giving us a list of measures that have been adopted and the state of implementation. That is not an evaluation. Citizens have a right to know all these measures have been taken. Are they effective? Because that is actually the only justification for such measures. Secondly, I think we should lift all the protection mechanisms to the European level. So, for example, we have I mentioned it yesterday, we have the so-called Police Directive, which is the twin sister of the GDPR. The Police Directive has a pathetic record of implementation by the member states, and by now it's ridiculous. If we're talking about interoperability on the one hand, and then protection is still in the form of a directive, which is not being implemented, we urgently need to replace the Police Directive by a regulation. That is the very minimum that we need. Then I don't think it's enough to have in every piece of legislation to have specific provisions for legal redress and data retention and what have you. No, we need general provisions that apply across the board, and maybe one step in that direction would be to transform the Charter of Fundamental Rights into a true Bill of Rights that citizens can actually use. Then all these, I mean, when we're talking about interoperability, when we're talking about INTCEN, let's say the quasi intelligence center of the European Union, they are all operating at European level, but oversight is still very much at local, at national level. The European Parliament should exercise real, meaningful oversight and have the powers to actually, summons people to come over and be held to account. And then maybe finally, we should also have a closer look, and this was also a little bit yesterday's theme, we should have a closer look at our cooperation with institutions and countries outside the European Union. I mean, I don't think I'm saying anything new in front of this audience if I say that a very large part of our security policies is being determined by Washington, not by Brussels. Some people think that, Brussels is a dictatorship, EU SSR and so on, but actually our security policies, like PNR, for example, are more or less dictated by the US. And what they do is they say, if you want to have visa waiver and travel freely without visa in the United States, then here is the list of measures you're going to take. PNR is one of them. Just 5 minutes before I arrived here, I was told that finally the Dutch government has put the Dutch PNR law on the table, despite all the case law of the ECJ saying that this not targeted but massive indiscriminate collection and storage of data is simply not compatible with the Charter of Fundamental Rights. But never mind, member states are pushing ahead anyway, and what they're saying is very cynical, saying, the citizen can go to court and challenge it, and then it's again up to one single citizen to litigate in court for many, many years and challenge this. So, and one final remark about the litigation. it's not really the topic of today, but a year and a half ago, the European Parliament adopted an amendment of mine calling for the creation of a litigation fund in the EU budget. That was adopted, and now the European Commission is doing everything it can to avoid implementing that decision and really creating a litigation fund. But when it's there, you can use it to litigate and challenge the issues that we're talking about today.
Thank you very much. That was really interesting and concrete proposals for reform. So,
Clara, thank you. Could you put the image? Okay. So good afternoon. Well, I could refer you to this image, and in what concerns about balance, I rest my case and I go home. And you all go home. In fact, the area of freedom, security and justice is coming to a very imbalanced situation. An image, words, 1,000 words, that's what it says. And in fact, how are we dealing with our security issues? We are setting up, creating more European systems. We are enhancing and providing law enforcement perspectives and functionality to border management systems. We are collecting more and more and more information. We are creating obligations for data controllers who process data for commercial purposes to retain data indiscriminately to be reused for law enforcement purposes. So we are enlarging the web, a decentralized information system. Sometimes people are not aware of besides the centralized information systems, there are lots of networks. This image shows that there are lots of networks of decentralized systems. That means that there are networks of central contact points and exchange information for in many sectors and across the EU. So this, we may say, that started with the principle of availability. So the principle that says that if you have data, you have to make it available to the other member state. So the idea was good because the idea was to improve cooperation among law enforcement authorities. Law enforcement authorities are not keen to share their own data, even at national level. They just leave alone and they don't share with each other, much less at EU level. Of course, you don't want to share your data, but you want to benefit from having access to others' data. In that case, you buy it. So what we have, of course, we have organized crime, transnational organized crime. It means that the authorities also, to be able to tackle criminality, should organize themselves and, of course, have an intervention transborder at transnational level. The main question here is whether are we doing this in the right way? Is this really necessary? All this panoplia of systems, networks, decentralized systems, exchanging points of information, are they adequate? Are they necessary? Are they proportionate? Clearly, no. In some cases, the European Court already say that this is not proportionate. But even that, we still keep on creating new systems. Now these proposals for the interoperability, which in fact is an interconnection and the creation of additional centralized databases at EU level, will be launched. This will be a revolution and in the European information system and will have surely huge impact on data protection level. Interoperability raises a lot of concerns. The first of one has to do with the so-called purpose limitation principle. The purpose limitation principle is a key principle in the data data protection regime, legal regime, in its architecture, and of course we need to depends on the purpose of the processing. All the assessments we do concerning the necessity, the adequacy, and the proportionality. If we don't have those boundaries well limited, We are unable to do this, this kind of assessment, so we are unable to apply the law and to apply it in a proportionate manner. Furthermore, and TJ already pointed out, these new centralized databases that will run in a centralized way behind the systems, which are still separate, at least artificially, these centralized databases will join data from a person, a vulnerable person seeking for international protection, a refugee, along with data from a convicted criminal. So this cannot be right. Even if you don't take 2 minutes to think about it, of course you say that this cannot be right. Then, and I would like to support the views put forward by Sophie in 't Veld about this, how legislation is presented to the Parliament and is presented to the citizens. The legislative process of the interoperability processes was at least it was very much creative, because the interoperability agenda determined how the systems will work, not the other way around. We had systems for different purposes, different systems. Then, with the interoperability, new systems are created, and at the same time, you are also revising the legal framework of each system in itself. In some cases, and this is a huge problem from a data protection point of view, there were systems that had some data processed, the necessary data just for a certain purposes, like Eurodac, and it was added more data to that system in order the system to better fit in the interoperability mechanism. So this was completely made the other way around. And we are facing this problem of having data processed which is not needed for the purpose of that system, just because it will help the smooth of the interconnection of the systems. Of course, the interoperability and all this array of systems we have poses a lot of problems from a supervision point of view also. Because supervision, which is now fragmented, at this point it's fragmenting, we are discussing how to improve supervision, and the recently adopted regulation 1725 2018 on the supervision and the data processing by the EU institutions brought some clarity on that and is pushing the supervision schemes under the framework of the European Data Protection Board. This is a good thing. It doesn't cover all the systems at this point, but there's a promise in the law to revise the systems by 2023, I suppose. So in order to adapt and to see how the supervision can be what we called in the 90s an horizontal approach, that we only had 3 authorities back then. It was the Customs, the Europol and Schengen information system, and the DPAs already advocated an horizontal approach. We were the same, we are DPAs, the member states are all more or less the same. They are not exactly EU member states. In some areas we have to the EEA states also, and to Switzerland in the case of Schengen. And not all EU member states participate in every system, like now Denmark opted out from Europol, and Ireland has a partial participation in Schengen, and so is the UK. So we don't have exactly all the same participation, but nevertheless, we need to have this horizontal approach. Because with all this scattering of systems, we need to have an holistic view to supervise. They are all of access. Europol and Eurojust access to almost every system that are on the face of Earth in the EU, and then the Frontex access others, and Olaf access another ones. And so this is really a web, and we need to have track on this. And this is not easy to supervise. It would be much easier if we only have one system, which in practice it's the same, but much more difficult to supervise. So it's important now, even with the law enforcement directive, that the data protection authorities at national level and also at EU level already have, now they have new powers. They have powers of authority, which they didn't have before, and it's very important because even in member states who already supervise law enforcement area, some DPAs only had soft power, so they didn't issue any binding decisions. They couldn't order the police to delete data, and it's very important to be able to do it. So now, under the LED, all DPAs will have the powers of authority, and it's important to make use and full use of those powers. I think that NGOs play a very important role in bridging, sometimes because they are in the field, in bridging between the data subjects and the DPAs. And the DPA, it's easier to convey information to NGOs, and then they also directly, they are in contact with the data subjects. But of course, one of the main challenges now is, on the one hand, for DPAs to implement effectively what the law provides, the guarantees the law provides. This means that they have to make full use of the powers, and also not to be afraid of the police, because we have different traditions, of course. We are not all the same, but it's not only the law enforcement sector or the police that have to change their mindset and to be open to fundamental rights. Also at DPA's level, we also have some shortcomings, and we need DPAs also to change their mindset. They don't look at a person whose data is processed immediately, instinctively as a criminal, but as a human being, as a data subject that deserves all the protection that the law provides. So this is also important. Then DPAs have two main problems, which is something that the EU has to solve, because at national level it's impossible. One of its lack of resources. National DPAs do not have enough resources, human resources basically, and also financial resources, but I would say human resources they are connected, but it's a more problematic thing. They don't have resources to go to everything and to play their role in full. And of course, the market makes more pressure than citizens, especially if we are talking about vulnerable citizens. So the priorities of a DPA, an average DPA, I'm not accusing anyone, because I think this is a general sense, the DPAs prioritize GDPR issues. So when you have lack of resources, you have to prioritize, and you go for GDPR because the market, big companies, data controllers, they exercise a lot of pressure. So it's important also for NGOs to make pressure on DPAs. And it's important for everybody to make pressure on the European Parliament and on national parliaments, because that's where the legislation is done. But there is another challenge that I suppose it's a challenge for all of us, and it is how to protect citizens when the law doesn't provide the sufficient guarantees. Because one thing is when the law provides, and we have to make sure that they are effectively implemented and guaranteed, but what we see in Europe, this trend, is that there are legislation, and more legislation will come that doesn't really grant the enough guarantees. So DPAs cannot implement something that is not there. This is a challenge for all citizens, also for DPAs in the sense that they have a common role, general role and mission to protect fundamental rights as such. And of course, they are able also, according to LED and GDPR, in principle, they are able to go to the court. So through concrete cases, maybe DPAs could also play a role here. But of course, we need time, we need resources, and this is a kind of closed circuit. So I'm not so optimistic. I'm an optimistic, of course, things will get better, but I suppose that they will get much worse than they are now, before they get better again. And I think that this conference is about democracy, and we shouldn't take democracy for granted, because it's in these small things that democracy is being undermined. And in the end, what we'll have, it could be just a formal democracy. And even though there are problems with the elections, so we need to act, to react and act. Thank you.
Thank you very much, Clara. I think there are a lot of questions arising out of that, but perhaps what we'll do is address all the questions at the very end, once we've heard from all our speakers. So without further ado, I believe Fanny is going to speak next.
Question. That's fine. I can speak now. Yeah, that's fine. That's fine. Thank you. Thank you. Well, first of all, thank you very much for the invitation to be here. I gather that I am the token law enforcement guy here, who's then supposed to sort of make up some arguments to counter some of the stuff that's been said.
Are you feeling comfortable?
I'm completely comfortable. I think it's important to say also to speak to Sophie's point on legislating and the way it works in the EU, that the high-level expert group that led to the actual interoperability proposals obviously was set up for a reason. It was because there was a problem that needed to be solved, and I think anyone who lives in Europe knows what the problem was. It was that we were within the EU completely incapable of protecting our borders and regulating the flow of migrants. And I don't think there's any country, including the UK, Germany, or anyone else, where that hasn't had serious political ramifications. So all this stuff is obviously, as it always is the case most of the time, when you legislate, you want to address an issue. And that was the key of the challenge. There were specific cases, there were terrorism attacks, there was organized crime, that it was very clear that we were not able to counter in an efficient way due to insufficient control of physical individuals. And this is an attempt to address that. And as you can see on the slide behind us, it's a pretty complex setup to figure out who people are. And to speak to another sort of general point, it's sometimes a little disconcerting as someone who works in law enforcement and with actual law enforcement officers, that the dialogue, including some of the things said here today, often seems to be that we're the bad guys. That giving personal data to the police is somehow fundamentally problematic. Obviously, police can abuse powers. That happens. That needs to be addressed within the confines of a democratic society through legislation and oversight. I completely agree with those points, and that can always be improved. But I think it's important to take a holistic view of this problem and to recognize that the only reason that we're sitting in a room having a debate in a democratic society is because there are law enforcement officers in Belgium that go to work every day to protect us. And that's basically what we care about. We want to make sure that society functions. We don't want information we don't need, but we do really want the information we do need. And that basically is personal information. That is being able to identify and resolve who an individual is. And that requires accessing all the databases that have been created that might give some piece of the puzzle on who is this person. Is he who he says he is? Has he been in another country previously? Is he wanted by the police? Is he wanted as a war criminal in the country he's coming from? There are multiple scenarios where, including protecting victims and vulnerable people, that the only way we can do that as authorities is to figure out who people actually are. And that's the key point, that we're doing this for a reason. And then there needs to be a safeguards around that. I think that's being evolved. I think the law enforcement directive is part of that. But just to take a point on something that Sophie said as well on PNR, I'm actually quite comfortable if the PNR directive was to be challenged in court. I'm not that worried. I don't fundamentally, because as a legal point, the Canada PNR case did not lead to the court saying that PNR is not legal. It says that there needed more safeguards to be put in place. Then you can have a debate about whether or not the safeguards in the directive are sufficient. But if you look at it actually as a data protection professional, I actually feel that is a very good example of what the court asked us to do in its jurisprudence on the data retention directive. It basically said, you need to take this stuff seriously. if you want to if you want to solve these important tasks of law enforcement, the court recognizes specifically that the most important task there is law enforcement and national security. Because it says explicitly in both PNR case, the Canada PNR case, and in the data retention cases, that only these very important objectives of ensuring law enforcement and combating serious crime and terrorism justifies the intervention into the privacy of millions of individuals. So the court clearly recognizes that we do the most fundamental task in society. It's not clear that the healthcare sector or any other sector in the public sphere would be given the same leeway. But the court says you need to do this in a serious manner, taking into account proportionality and necessity. And I think the PNR directive is just that. It creates a specific unit where only dedicated officers can access this data. They can only share the data under oversight internally by lawyers and a DPO function, and external oversight of a data protection authority, and by documenting specific legal tests of necessity and proportionality that needs to be carried out in the individual case. So that is data protection by legislation, data protection by design through legislation, in my view, and that's what the court expects us to do. So I think that is the case model going forward for what we need to be doing better. So I'm not really worried about the PNR directive. I could be proven wrong, but that's how I said it. I would also say that to Clara's point on the issue of interoperability and the fact that many of these databases were created for different purposes. It sounds almost like, and I know there's also articles that have been written to the point that in some way the principle of purpose limitation forever prohibits the legislator of changing their minds. It's like it's being said that because, let's say, Eurodac was once created for one specific purpose, we are forever and ever prohibited from deciding that those data might also be useful for another purpose. That is, in my view, clearly not the case from a legal standpoint. Of course, the legislator can, within the confines of the treaty and fundamental rights, decide that data can be used for another purpose. That needs to be proportionate and in accordance with the jurisprudence of the court. But there's nothing in the treaty that says you can't change your mind as a legislator and say, if we want to make sure our citizens are safe, we can use data originally for one purpose for law enforcement.
It's actually in the law that you cannot.
Yes, but the law can be changed. No, there's nothing in the treaty that says you can't do that. You need to observe data protection standards, but clearly that would require a constitutional norm or something on the treaty saying you can never change your mind as legislator. It needs to be specific. It needs to be a task that is proportionate to the data you're processing. But clearly, from to say that because we once decided one thing, we can't later add on other purposes is just legally not the case, in my honest opinion. So I think we need to have the debate on a case-by-case basis sometimes, but also on a general sphere. And going back to the interoperability proposals, if I were to be critical, I would say one of the problems I think we're going to face is that it is an extremely complex set of rules we're building. It's going to be detailed rules on technological standards, on who can access which data at which time, which may in many cases be justified, but I could be worried, just as a personal view, that this is going to be very complex to build. And that might be a problem, because I think the citizens expect that we solve this issue going forward, that we become much better at protecting them through a responsible use of data to solve the task of law enforcement, border control, and immigration.
Thank you very much, Christian. I know Sophie has to leave very shortly, so perhaps we might hand the floor over to her for a moment to respond.
I can do this in 1 minute, but I cannot leave this room without responding to this, because actually you got me extremely worried and even more reluctant to endorse legislation, because clearly, first of all, it is legislation that you cannot indeed change the purposes just like that. You would have to need to pass a new law. That's
what we're doing.
No. Yes, okay, but it's still function creep. I mean, I happen to know the history of the Eurodac file a little bit. When we were reluctant initially, they said, "Oh, don't worry, this is only just to identify people." Okay, I still didn't like it, but Parliament endorsed it. And then the next step was, oh, this is very good. We can actually give access to law enforcement authorities. We didn't like that, but we were arm-twisted into adopting that because of the asylum package. And now we're in the third stage. It's called function creep. Okay. Now, and it's got nothing to do with purpose limitation. If you have a law with one purpose, then no, you cannot add on other purposes. And I'm very happy that that's what the law says. Secondly, on PNR, you said, we don't want information that we don't need. Well, very good. We agree on that. The point about PNR is, and this is what the ECJ has said, is not just that there are not sufficient safeguards, but that it is disproportionate. Why? The difference is that what we all agree on is that information must be available for individual inquiries, for investigations in specific cases. PNR is about mass surveillance, and it's not about data that identify people, it is about behavioral data, essentially. Okay? So it's a completely different ballgame. Having access to data in a specific inquiry, absolutely, but not mass surveillance. And that is precisely what the ECJ has addressed, and that is the argument that applies not just to the Canada Agreement, but also to the directive. And finally, I'm interested you say all this, and also that you're a big fan of interoperability. I mean, I'm a big fan of the principle of interoperability. But you know what? When we were working on the PNR directive, my group proposed an amendment that would oblige the member states to actually share information, because that is really the only justification for an EU PNR directive. Otherwise, every country could decide for itself to collect PNR. The only justification to have an EU directive would be if that data is shared at European level. And you know what? That was blocked by the right-wing groups and by the member states. So then what's the point in having a PNR directive if we know that data is not being shared? Then there is no point. And that means if we don't get additional security because the data is not being shared, that means that the whole justification for the collection of data lapses, and that basically it's a violation of the treaties that say that the collection of data or the use of data should be necessary and proportionate. Okay, there's a lot more I could say, but I apologize. I apologize. We have to go out. But we'll meet again in a couple of years when we have defeated the directive in court. Thank you very much.
Okay, thank you so much. So without further ado then. So without further ado then to our final speaker. Fanny, if you'd like to take the floor.
Yes. So I think that now the scene has been set, all the problem has been mentioned. And I would like to talk about the challenges ahead for the EDPs as supervisory authority of EU bodies active in the field of the area of freedom, security and justice, how to make these rights efficient. So we have become one additional data protection authorities in this field. We got new supervision power over Europol in May 2017. We'll get new one over Eurojust at the end of this year, over EPO next year. And data processing activities of EU bodies that we were already supervising, such as Frontex or EU LISA, are not only expanding, but they're also changing in shape and nature. So, for instance, EU LISA mandate has been strengthened to help EU information system for security and border management to interact more efficiently, to improve the quality of the data they hold. Frontex mandate is expanding, not limited anymore to migration management, but reaching out to security of EU border. For instance, Frontex is in charge of the creation and management of the ETIAS central unit. And the supervision of this data processing activity brings us a specific set of challenges. So, as you know, data processing activity in that field are opaque to the data subjects, difficult for them to know who is processing the data and for what purposes. Data subject rights are restricted, and this justifies specific instruments. So think of Chapter 9 of the EU DPR, Europol regulation, Eurojust, etc. And even when they want to exercise their right of access, they might not even be allowed to get this information because of the need to protect ongoing criminal investigation, public security, etc. the impact of this data processing activity on data subject is very high as well. So these personal data are collected and processed in order to allow public authority to take decisions which have a very serious impact on data subject rights. So there is a risk of being wrongly suspected, of being discriminated, of being denied asylum, etc. And many of these data subjects are vulnerable groups of people. Think of migrant refugees, but also minors, missing persons, etc. And what is new, and which has been addressed, I think, in this panel, is that the emergence of a structural data exchanges between EU bodies and between national authority and EU agencies. That's what this graph illustrates. And this is linked to a triple phenomenon. Increased global mobility changes the nature of the security threats, which become more diffuse. This brings a dilution of the separation between migration management and public security. Lines are blurring. And we have the technology that allow data controllers to connect the dots as it's advanced in a much cheaper and efficient way. It's easier to connect database, to mine the data, etc. And even if we are not there yet, it is possible to do it. So, we have identified three main challenges for the EDPs in order, if we want to play our role as data protection authorities of EU bodies and ensure an effective protection for data subjects. First, getting a concrete understanding of the risks for the data subject, supervising an environment where data flow with the risk of dilution of responsibilities, and support data subject in the exercise of their rights. So, with regard to the first challenge, getting a concrete understanding of the risk for data subject, the risk discourse in the area of freedom, security, and justice is mainly driven by the risk that global mobility poses to EU security. So, we also talk about, for instance, the PNR context of risk profiles, depending on the level of risk some person poses to EU security. Our role as data protection authorities is to take into account the risk increased surveillance of EU borders posed to individuals. And in terms of supervision, this means to get a concrete idea of what is happening on the ground, but also who is responsible for what. So we'll get this information from complaints from data subject, but this might not be sufficient. Just to give an example, since we've been in charge of the supervision of Europol since May 2017, we received only 4 complaints, and 3 of them were not admissible. And this better understanding of the risk should also help EU bodies to improve the level of protection that they afford. It's a win-win exercise, I think. The second challenge is to supervise an environment where data flow, so represented by this graph. So between EU agencies, first, we know that each EU agencies have procedure in place to monitor data transfer to third parties, to record and log the transfers. But we wonder, is that sufficient to only monitor that? Should we instead follow the data? Instead of looking at only one data controller, should we look at how data flow over the network? Identify all this information is shared throughout the network and check what happens each time to data in order to identify maybe flows in the protection or breaches. I will give you the example of hotspots. So hotspots are camps where migrants crossing the Mediterranean are received in Greece and in Italy. And here they are registered, identified, and fingerprinted. So the data are collected by national border guards and then cross-checked. First with Frontex databases, and in certain cases with Europol's database when there is a risk of for EU security. They also exchange with EASO and Eurojust. But what it means that information between national member states and EU agencies is flowing, is going back and forth. And in the new instrument of Europol, Eurojust, Frontex, we can see that there are provisions to foster exchanges also between these agencies. So you can see the complexity of supervising such an environment with so many actors, but also so many supervisory authorities as data go back and forth between member states and EU agencies. And this means that such complicity should lead us to deepen our existing links with national DPAs. So Clara has mentioned the work under the coordinated supervision. At the level of Europol, we already have a provision that when we receive a complaint for a data subject, we should consult national DPAs as well and act together. So this shows a really strong need to act together. There is also a new role for political supervision, for instance, the Europol regulation, which creates a joint parliamentary scrutiny group. And the question for us will be, how can the EDPs best support the role of this group in their political supervision of Europol? And my third point, last point, the third challenge was how to ensure effective data subject rights and remedies. And again, we're asking ourselves, should we here also follow the data and not limit our action to one data controller? Should we also connect the dots to understand how a decision is made, on the basis of which information, how the initial information provided by the data subject has been enriched by each data controller? If we don't do that, there is a risk that we will miss the bigger picture, and thus we will only afford partial protection. Maybe the simpler example is the propagation of inaccuracy throughout the network. Another question is, what does the exercise of right to access, for instance, mean in that context? Does it reach out to transfer made to other controllers? Does it reach out also to the analysis performed over the data which has been collected? So to conclude, I think I believe we cannot think in isolation anymore. We cannot focus on one data controller, but we might need to start looking at how the data flows through the network in order to provide effective supervision. Thank you.
Thank you very much. I know Clara would like to make a couple of points before we throw the questions open to the floor.
Very quickly, just to react a little bit, not entirely because Sophie already did that, but just to clarify some aspects concerning Christian intervention. First of all, concerning the purpose limitation principle, there are no two main purposes, like law enforcement is a purpose in itself and commercial needs is another purpose. In data protection, things are not like that. Those might be objective sectors, but they are not purpose in itself. The purpose has to be specific, determined, which means that the law enforcement, the access by law enforcement or the use by law enforcement in itself, it's not a purpose from a data protection point of view. You have to detail, like to combat organized crime in this area, in this, you have to specify. So what we have with interoperability, and it has nothing to do with changing purposes, of course the legislator can change the purpose and passes the law that changes the purpose. The question is, for instance, let's pick Eurodac. Eurodac, because of the kind of data subjects, Eurodac was subject, when access to law enforcement was granted, which was previous to interoperability, when access was granted, there were some adduced safeguards, like in what concerns, for instance, transfer of data to third countries, for the risk that this may pose to the requesters. If the asylum was not given, was not granted, and the person had to go back, they might even be killed. So the situation is very particular, and there were some specific safeguards for that system, for that data processing, because of the specific purpose of Eurodac. The specific purpose of Eurodac was that data, it was only taken and processed to determine the responsible member state to handle the request, nothing more. This was the main purpose. It's a very specific purpose and very, very little tiny one. What happens also when law enforcement had access to Eurodac, there was a huge checklist that law enforcement authorities had to check. Like first they had to make the PRUM checks, then the request was assessed by a non-independent unit inside the law enforcement, but even though there was an assessment that is documented and has to be justified, and after having checked all the other databases, then the access to Eurodac was given. So there were safeguards. And there were safeguards that were tailor-made to the concrete situation, concrete system, and the concrete characteristic or nature of the data subjects, like Eurodac, which is a very specific one. So with the interoperability, what happens is that all those different purpose limitation and the purpose are different from the systems and kept different in the law, even with the interoperability purposes. It kept different, but the borders are blurred because you have behind a centralized database with all the data. And this will poses a lot of problems and from a data protection point of view.
I will have to intervene. We have just 15 minutes to the end of the panel, and we need to start the discussion.
Okay. Just to finalize, and I agree, of course, that we have to assess when and if the law enforcement authorities really need to access data, and in which conditions they need to access data. Because my question is, there are a lot of legal access already granted in the law, like Europol access to seas and customs. And could you check the statistics? Did Europol, from the moment, some years ago, for instance, this is just an example, that had the possibility to access the seas and the customs information system, did they exceed it? No. Why? Because they didn't need it, of course. Because Europol, when receives data from the member states, the data is already worked and checked and so on. And member states at national level, they also have access to seas to check the data before they send it to Europol. So, and then, next step. We can't have this because this could be an argument against our will and justification why we grant access to Europol to seas and customs. Second step, please artificially increase your statistics. Start making batch searches is just in case you don't need, but start making this. So this does not reflect the need for the law enforcement to have access to data, because when that need is there, of course they should have access, but on a case-by-case basis.
I know Christian would probably love to respond to that, but I think we had better hand this over to the floor. So please, if you'd like to come up, take the microphone, and this gentleman here first, and just briefly introduce yourself, if you will.
Yes, my name is Tijmen Wisman from the Free University of Amsterdam. Thank you for the panel. I have a short question for Mr. Svanberg about the PNR directive. It is not struck down in court, but actually I investigated this directive a little bit. And to me, it was very surprising that it wasn't struck down, because one of the requirements is obviously that it has to be necessary, there has to be a pressing social need. Now, I'm sorry I wrote this is very pretentious, I'm not trying to, so according to the Canadian Border Service Agency, they said that they caught 178 persons between April 2014 and March 2015. And the interesting thing is that to get 178 travelers, this was 178 travelers out of 28 million passengers. Now, this means that all people flying between Canada and Europe are being profiled, because on the basis of profiling, the people that were being captured weren't terrorists. For terrorists, actually, the measures are already in place. These are people that are, suspected of human trafficking, but it's a very small number. To put it, we cannot even imagine it. It's one person in 157,303 persons. That means that you could fill up the Barcelona stadium, the Ajax football stadium, and one people in those stadia would actually, one of these persons would be guilty. Of course, my question to you is, would you think that that is necessary? But I have to make a side remark. The interesting thing is that PNR has actually been pressed by Prime Minister Valls from France, and he was a frantic supporter of this directive, but he is also a frantic supporter of Safran, the company that is actually introducing PNR. And there's a very interesting article on Euractiv that actually shows an interesting connection between Prime Minister Valls and Safran, because Safran is located in Évry. Évry is a small French town, and he has actually been the mayor of this city for 11 years. And he actually visited the site in 2016 saying, hey, I'm going to work for long-term employment in your region. To me, that evidence points in another direction, but maybe you can help me change my mind.
Thanks very much. We don't have a huge amount of time, so what I'm going to suggest is we take one or two more questions and then ask each of our panelists to address the overall package. So if there's anybody else who... Yes?
Hi, my name is Eugene Burmaka. I'm studying Information and Communication Technology Law at the University of Oslo. I have a question to the whole board. Maybe any of you would like to answer. There is an EU directive concerning the automatic exchange of information for tax purposes, which is aimed to implement the OECD CRS into European legislation. Which risk can you see here, and what could be improved to make it more compliant with the data protection, if anything should be approved at all? Thank you.
Thanks very much. And do we have perhaps one other question, or is that it? Okay, if that's it, then perhaps we'll give Christian a chance to respond to the PNR question and then ask our other two panelists to finish up.
Thank you, TJ. Well, I can't speak to the Canada example as such, but I think the important point is to the question of whether or not that it's necessary. Well, the Court of Justice thought so. It just said you needed more guarantees around the PNR. So the only ones that matter said yes. Yeah, I can speak to the Canada example, but what I can say is that since January 1st, I've been the DPO of the Danish PNR unit, and we're definitely going to end up with more than 178 people that we care about over a year. I can guarantee you that. So I think maybe it's because that the scope of the Canada PNR agreement is somewhat more narrow. We can use PNR data for a long list of serious crimes. And that in itself is going to be relevant in many cases. And from the day we took over the already existing PNR setup, people were being stopped, arrested, and drugs were being impounded. And I think it is completely beyond question that PNR is relevant for law enforcement. And I think over time, as everyone has implemented PNR directive, we'll be able to document that through pure statistics and say that this is useful. And it's useful for, and then you say, all these millions of passengers are being profiled. In a sense, of course, you're right, because there's rules applied to the data, but it's not like every single passenger now has a profile that has been made where someone is predicting who they are or what they want to do. It's about identifying travel patterns that we know are interesting for people smuggling drugs, for people smuggling human beings, for foreign fighters that are returning to EU member states. It's about using big data in an intelligent way. And I think you should really view it as part of this package as well. It's about taking back control of the borders. We've sort of given up internal borders in the EU. We want to protect that principle, but that means we need to be much better and intelligent, especially in the face of international airline travel, where if you compare it to 30 years ago, just jumping on a plane was sort of an exclusive experience for most people. Now it costs you, £40 to fly to London and Copenhagen. So that's the way the world now works, and we need obviously to keep up with that. And that's what's informing all these proposals, is that law enforcement needs to keep up with society, and that's expected of the political level and the population.
So, Fanny, would you like to respond to those questions also?
No.
Clara?
Okay. I just would like to make a clarification as PNR concerns. Because, of course, every country, and that's what the court acknowledged, every country has the right to monitor and to know in advance, in this case, a foreigner that is going to enter into that country. This already happened since the 30s or the 40s with the Chicago Convention, what we now call the APIS data. The APIS data was there is already a directive in the EU, and it's already exchanged. So this allow me to allow the authorities to check the person, the identification with accurate identification, because it's with the document, accurate identification, unless they are false. That's another question. But identification of the person who is entering the country. PNR has more data. Not all the data that PNR actually has in the manifest of the passenger, but the directive cut some data off, but still has more data and has all the data and all the changes in the reservation and the credit card when there's a credit card. And this kind of information is being told, and I agree, that might be important and relevant to detect criminals, more in terrorism in this case. But nevertheless, what the court said, and in view of the first purpose of the PNR, which is to check the border and the person who is entering, in order to decide whether I'm letting that person going in or not in the first instance, and then if that person makes anything wrong in my territory and I'm able to react. This is what the court said, that it was admissible. But the court said, and this will leave out the secondary use and most important use of this, which is to detect patterns. Is very relevant for drugs, I'm told, and at national level they told me the same. Not to terrorists, but to drugs it's good, it's a good database, but that's what the court said, you can't use it. When the person leaves the territory, you have to delete the data unless something went wrong, unless the person was committed a crime. So this is completely different, because if you look at the court doesn't allow you to process the PNR data as such. It allows you to process data only when you are checking and screening the passengers before they are entering your own territory. But after they leave the territory, and with the EES system, you can control when they are leaving the territory, at least by plane. You have to delete the data. So no 5 years periods to make profiling and to detect patterns with personal data. If you, in fact, only want to detect patterns, you anonymize irreversible, which is not the solution. You can do it and just work on patterns and don't take any added value, specific added value, which is a different thing from what is now. So I think that it will be interesting to see how the court will assess this, because in the PNR agreement with Canada, the court was very, very, very detailed, so detailed, like it was teaching the legislator to see how you can make an agreement to transfer data. And as to the question on tax, exchange of tax info, didn't understand quite well the question, but there are a lot of legislation in EU providing for that exchange of information. You can exchange information through the financial units, if it's a different thing. Then you have all these FATCA agreements.
It's FATCA-like solution.
And we are dealing with it at GDPR level. With the board. The board will issue a statement very shortly.
Well, I'm actually not the panelist, so I will only add to this second question about the exchange of tax information. I think the data protection authorities, after some years, are actually coming back to the discussion they had years ago about FATCA. Because FATCA came to the discussion of the working party of Article 29 very late, when there have already been some decisions on the national level and the data protection authorities didn't react. And right now it looks like that in this next round, when the European system or all global system is going to be established, the data protection authorities are going to have much more to say about the real use of this data in the global exchange.
I think then that's all that's left for us to say. Is we've only managed to cover maybe one tiny part of that vast diagram that's above you. What I will do is I'll tweet out actually a link to that diagram for people to see if they want. TJ McIntyre is my Twitter account if you want to see it. And just to thank you, the audience. Thank you very much.